So, as I usually say in the group, hey, barristers and solicitors, I consider once you have become licensing candidates, you all are barristers and solicitors. You are all lawyers. This is something technical terms which LSO allows us to use. And let me say you one thing else. What should I greet you? At my place, sun is rising. At your place, sun is setting. So it good day, good morning, and good evening to all of you. Let me say you, it's pleasure to have so many persons in my class, and I assure all of you that you will be benefited if you give me your 100%. I am ready to give you my 100%. My 100%, as I have already committed, includes that I will be telling you all the things whatsoever I have. I won't be concealing anything. Only preposition which I want is consistency, discipline. Consistency is the key to success. When I was preparing, I will start with this. I found it very difficult in the very beginning. But the moment I start doing it regularly, it was easy. Why so? Because everything has a reason. Now, let me say you that the moment you start preparing for barrister and solicitors, there is lot of material, lot of things to remember. And the moment you become barrister and solicitors, everything needs to be recalled on the flick of a second. Why I say so? Suppose a client is sitting in front of you. You do not know for which purpose he has come. You do not know that what question he is going to ask. And if you are not ready with the answer, and if you are not answering his questions, then of course he is not going to engage. Once he's not going to engage you, you will not be getting business, you will not be getting an opportunity to appear before the court or do his work. So you will be left with no other option than to cut a sorry fee. Now, let me say you one thing more. Before I formally start with the syllabus of LSO, that you should have a plan in your mind, what you are going to read. Time and again in the group, I have asked that you need to have visualization. What this word visualization means. Visualization is an idea which gives you thinking pattern about the situation or circumstances at hand. That is my way of thinking. You can have your own interpretation of visualization. Now, let us visualize what we are going to read not only today, but also in the days to come. Let me say you one thing more, technically only. People will keep on joining, so I will have little distraction in first few minutes because I have to allow them to join. Let us have a brief scenario. We are reading today, means to say yours Thursday, somebody's Friday, that we are going to we are going to read Barrister. On the next day, we are again going to read Barrister. Again, on next day, we are going to read PR, which is joint for barrister and solicitors. Then on the next day, we will be solicitors. Next 2 days, we will be studying solicitors. And my methodology will be go subject by subject. People kept on asking me that how I will be doing. In 2 days, how I will be covering 5 subjects. I told everybody that I won't. Why so? Because this is my firm belief that if you do not complete one subject at a time, then you do not recall the things studied last time. Say today I take civil litigation, tomorrow criminal law, day after family law, and then day after public law, or say anything. I suppose the moment you come after a week in civil litigation class, you will be facing difficulty. So I will be taking subject by subject. In barristers, we are going to start with civil litigation. In solicitors, we are going to start with what we call it as real estate. Why I'm taking PR joint? Because it's a joint proposed by LSO, the same. Second, the point is there is no separate section in the exam for PR. Once it's all over, it means we have to, while reading this civil litigation or any subject of LSO, total are 8, 5 of barrister, 5 of solicitor, 4 of solicitor. Comes out to be, my mathematics is not weak, 9, but PR is same, so that is why 8. I want everybody's participation. Why so? Because speaking for a long time is not difficult, but becomes boring to listen, listen, and listen. And secondly, I'm not kidding, but I should know that everybody is listening, nobody is sleeping at least. Because that is my like presumption only. If you keep on listening, even the best things needed for you, you may feel sleepy. So let us have a visualization of our syllabus. We are going to start in barrister civil litigation. If you have pen and paper, that would be so nice. If you have printed material of LSO, you can jot down upon that. Because let me say you why I say so. Whenever I kept on pondering upon these pages, whatsoever we are writing today, up to the exam, the day I appeared in the exam, this gave me confidence that what I am doing. Let us start with civil litigation. Civil litigation has 20 chapters. Bird eye view will help you to reach your goal. And this is something we are doing it for the very first day. Civil litigation, 20 chapters. I have also written on my pages. 190 pages. Sometimes we may fed up, then number of pages are going to help us. How many have left? Because we cannot remember the whole material. It will be recalled. Whenever you will be attending your exam questions, when I was attending my exams, barrister, maybe solicitor, my teacher's words were knocking in my brain. The same I tell to you. Whenever you will be attempting your exam questions, you will be recalling what was discussed in the class. And believe me, you may not able to remember everything, but your brain is the biggest computer which clicks appropriate data at appropriate time. So coming back, civil litigation has 20 chapter, 190 pages. You will be getting 60 to 65 questions. PR will be all over. If I am to bifurcate, 40 questions will be purely from civil litigations. Of course, this is something guesswork based on past experience. PR questions will be 20 to 25. Of course, there will be PR will be all over. I repeat, 60 to 65 questions of civil litigation, 40, 35, 40 will be purely of civil litigation, and PR questions will be 20 to 20. Of course, clubbed with the civil litigation. Then coming to criminal law, we will have 14 chapters, 155 pages. Approximately 156, one may call it as. So what I want to say is, another viewpoint is 14 chapters, 155 pages, 40 to 45 questions. Once you have 40 to 45 questions in the exams, you will have a brief scenario what I'm going to study. Then comes the family law. Easiest and trickiest. Of course, this adjective has been prepared by me, not by LS. 16 chapters, 130 pages. 40 to 45 questions. PR is all over, in criminal as well as in family, civil litigation, or public law. Now coming to last, public law. I'm talking about barristers. Public law will have 9 chapters, 70 pages. Really, it gives me confidence that how much I have completed. This was when I was preparing for my exams. I cleared in first go first attempt only because of the factor because my teachers were good. And if your teacher will be good, I will be good to you or to I will be sincere to what I am teaching to you. I suppose you are bound to pass. I know I'm using the word bound. The only point is of concentration. In NCA policy and programs, you might have read that NCA is looking for comprehension and time management of your knowledge. Of course, LSO has not put it in black and white, but still LSO says if you go on reading the detailed policy and guidelines of LSO or rules, particularly the LSO rules, which are also the part of your this LSO material, you will find that they are looking for. I will give you visualization. You are standing before a judge. First, we have discussed you are before a client. Now we are in the courtroom. We are before a judge. Judge is waiting for your utterance, what you are going to speak. He may have different sort of questions about the matter in question. Of course, you can look into pages. He is not going to take your memory test. But of course, in the paucity of times, he will be constrained to look for appropriate answer. If you are able to give appropriate answer, he is going to give you the requisite relief, requisite benefit in favor of your client. Because of course, you will be representing your client. The point is recalling why I'm stressing so. This is something known as brain mapping technique. What we are going to do in the class is brain map. If you can map your brain according to LSO material, if you can recall the points discussed in the class, and if you can recall your midnight oil lamp burning moments while attempting each question in the exam, whether it was on the left side of the LSO material, on the right hand side, upper portion, middle portion, lower portion, then you are good to pass the exam. Nobody can stop you. So that is what I call it as concentration. Concentration, suppose you are hearing my voice, you come across me, say after 30 years, you will be immediately recalled that it is Mr. Manu Jindal's voice. Why so? Because your brain will tell you that this voice in thousands and thousands or lakhs of voices you have heard, your brain will tell you one person, Manu. So this is how LSO material or LSO reading is going to work for you in the exam. The moment we start discussing the syllabus, we may not have time to discuss all these things. So kindly, please do have a concentrated effort. Last thing I was going to tell you about public law. I do not forget where I was because I have the written material. So a lawyer is not prohibited in using his notes. Same says LSO. LSO also allows you to use your material, charts, indices, papers, anything which can help you to answer their questions. But they are looking for 160 questions. I never say what will be the percentage. You should aim at 160 questions. We should not leave any stone unturned. So I emphasize, I insist that you should aim at attempting 160 question and 160 should be correct. Then in March and November exam, 120 may be the target. In June, 135 may be the target. So you should be well conversant with the whole of the LSO. Public law, 9 chapters, 70 odd pages, even and odd pages, 10 to 20 questions. Total becomes to be 160. Just repetition in a minute. Civil litigation, 20 chapters, 190 pages, 60 to 65 questions, 40 plus 20 to 25. Now, one factor to add at the time of repetition. 5 fact pattern questions. Minimum. Anything can change, but 5 will be there. Fact pattern. Now the LSO has become little strict. Every question seems to be fact pattern, but LSO has particular binding upon that to ask minimum of 5 fact pattern questions. Criminal law, again 5 fact pattern questions, 14 chapters, 155 pages, 40 to 45 questions. Family law, 16 chapters, 130 pages, 40 to 45 questions, 5 fact pattern again. Public law, 9 chapters, 70 pages, 10 to 20 questions. But fact pattern minimum should be of 2 to 4. Because this is the area where LSO experiments a lot, public law. And believe me, public law questions decide whether you are going to pass. If you are little not confident of attempting all the exam questions, then public law is the key to the success. Public law will decide whether you are going to pass, because these 10 to 20 questions are most important. You never know after attempting 100 questions, 100%, 160 questions, how many will be correct. When I attempted, I was sure that my 99% were correct. When I came out, somebody met me. Of course, in our times, it was online. So somebody discussed on phone. I was distressed. These are 96%. Somehow, after a few days, it was up to 95% that I am 95% correct. So I suppose once you are so much sure, you are bound to pass the exam, and pass percentage in your case in March exams will be around 75 to 80%. That is what LSO data predicts. LSO never issues any official data, only predictions are. In June, it will be 10%, 8 to 10% higher, 85 to 90%. After this brief overview about exams, about this barrister class, of course, one is left out, PR, 15 chapters, 140 pages. How many questions? 320 questions, 320 questions. Because that is my firm belief, PR will be all over. 160 of barristers, 160 of solicitors, 320 questions from BPR. So that is why I have kept 1 day for PR, 2 days for barristers, 2 days for solicitors. That is how I can put my project before you, of course, telling you that how I'm going to go for it. This is something overview. Once you have this overview in your mind, believe me, what else we can do? Use of indices. I will give you on the very first day, in first few minutes, the brief scenario. What are the indices? Means to say, what I should call it as, when you are in difficulty, they are going to help you. When you do not know the answer, they are going to help you. When you do not recall the things, they are going to help you. When you do not find the right answer, with the help of your brain, or you are very, very perplexed state of mind, whether option A is correct or option B is correct, then of course, two you can outrightly delete. But 2 will be similar, not same, similar. Once 2 are similar, 10 questions are there in which you are unable to decide which way to go, whether with A or B. Then indices are the real things which are going to happen. Of course, otherwise as well, I have seen the papers. I have seen the students, not the paper, sorry for that. I have seen the students who do not go for anything else except the indices. Particularly the university students of Canada rely mainly on indices, and they attempt out of 160, that is what I have heard of, 90 to 100 questions from indices. So it is your cup of tea. Whether you go for 190 to 100 questions with the help of indices, or you leave your brain for at the time of difficulties. What we are going to do with the indices in the class, we will learn indices. What is the learning of indices? This is something seems to be an odd thing to hear. Why so? Because let me see. Indices needs to be learned First, they should have A, B, C, D up to Z. You should tab them to decrease the flipping of pages time. Second, you should have important this flags on your pages, which can directly take you to that page where they can suggest you on which page of LSO material is the answer. What are the indices? LSO material, say, we have talked about civil litigation, 190 pages starting from 141 page number. 141 is the page number from where it starts. It goes up to somewhere around to 320. So indices tells you this is the topic and this is exactly located at this number of page. Once you know that your answer is at that page, you go to LSO material, read that one paragraph, which you have already read during your study or during your class. Then you have the answer. The doubt is cleared. Now, how I bifurcate? Because you have very less time. When I attempted the exam, we had 90 seconds to attempt one single question. 90 seconds means to say, of course, you have little more because there is no break time. Break time is included. It will be 4 hours, 30 minutes divided by that, little more. But if you use washrooms or do some refreshment, it will be decreased, but 90 seconds are secured. So let us talk about those 90 seconds. What are those 90 seconds? Those 90 seconds, I take it as this is something my way of telling you or my way of doing it. You may have your own, but I suppose if after a research things are seen that this is good, you can also adopt it. Nobody has got the copyright. Nobody has got the patent as even IP laws. So let me say you 25 seconds to 30 seconds in reading the exam question and understanding it, what the examiner is looking for. Next 30 to after 30 means 25 to 30 in understanding and reading the exam question. Then in 25 to after 25 to 30 seconds, you have to spend 15 seconds, precisely 15 seconds to 20 seconds in looking for your indices. Reaching at your indices, go to appropriate page, find the appropriate topic keyword. That is the appropriate term keyword. Once you are good with the keyword, say 45 to 50 seconds have elapsed. Now you are to go to LSO material again, spend 15 to 20 seconds. You are recalled of your answer. You got your answer. 15 to 20 seconds, 65 to 70, you have already spent. Now remains the 20 seconds. 20 seconds is to give the answer. You are safe. 90 seconds you have consumed by way of 25 to 30, 15 to 20, 15 to 20 again to transfer yourself to the LSO material which is readily available to you. Then of course 15 to 20 seconds to transfer your answer to your, what do you call it, as a answer sheet. I forgot the exact technical name of that. If anybody can help me, I will be thankful. But still, that answer sheet, since you are going for in-person exam, you have to shift that. And please be aware that you are going to give the appropriate question the same number. So this is how the indices can be used. Indices gives you good number of marks. I also obtained certain marks on account of indices. Now coming to the last part. What we are going to do in the classes. Of course, I will be providing you charts as I am already giving in group. You will have number of charts. Even I tell the students that you should also flag the charts so that you can reach the charts. Charts have a different methodology. We will be discussing in the class how to use the charts. Because how to do the things is more important with the LSO exams. Now coming to the last part, we will also be doing exam workshops. What are these exam workshops? We have a rapid fire type of question answer sessions in which no test of yours will be there, but you will be, what I should say, that you will be programming your brain to flip the pages instantly. Don't waste the time in flipping the pages. Reach at the appropriate place in LSO material, in indices. In my workshops, I always advise print the indices and bring indices along with your LSO material. Why so? Because once you have that, you get conversion to the examination hall. That is what examination workshop is. Of course, we will have a lot of questions. And at the outset, I am submitting that those examination questions will be prepared by us based on our experience that has got absolutely nothing to do with the exams. We are not going to provide any sort of examination questions, or we are not going to provide any set of exam questions, maybe 500, 700, or 600. We are going to give you practice based on our own presumptions. Questions will be always be different, and due to this year's LSO developments of some fraudulence or cheating practices. That is why I need to submit that those questions will not be in any manner relate to the exams, or we will not be providing you any set of questions which will be part of the exam. Even one question may not be the part of the exam. Of course. Now, what is the use of doing if any question will not be the part of the exam? Of course, this is a legal disclaimer. But one thing you should remember, from where the LSO is going to ask the question? From LSO study material. What is LSO study material? LSO study material has got certain 190 odd pages in civil litigation. If you have 170, 190 pages in civil litigation, can LSO go beyond that? The answer is no. I assure you, not even a single question will be asked out of 190 pages. Do LSO have got super duper brains? The answer is no. The best of my mind, no. LSO do not have. They need to prepare all the questions from these materials. What we are doing, we are also preparing the questions from this material. If coincidences are there of matching the questions, that will be purely incidental. Because material will remain to be the same. State law will remain to be the same. Family questions will remain to be the same. Civil litigation will remain to be the same. Structure of the courts will remain to be the same. A state list will remain to be the same. Anything, demand notices list, which we will be reading today, will remain to be the same. There will be thousands of topics which we will be covering during this LSO study. But believe me, in all those materials, we will be touching LSO questions. So LSO questions will not be from outside, but still I'm submitting that it will be like purely coincidental if any of the exam questions comes out of those questions. This is something legal disclaimer as well. Now, this is all about, if anybody has got question about anything before I plug in my laptop, just a moment, please. Before we start with this today's study, and it will go on, these things will not be discussed time and again. Of course, you can have your own question. If anybody has got any question regarding this all procedural things overview, one can come forward and ask the question. I'm ready to spend 5 more minutes or more minutes, because I have already spent 30 minutes precisely. That is what I have fixed for today, because this overview is going to help you in the exams. You can come forward, unmute yourself and ask the question. I'm ready to answer as far as possible. No question means to say good time, means to say I'm safe. I'm not being tested. So good. Now let us start with civil litigation. I purely believe that all of you have got your LSO material ready with you. And of course, charts which I have supplied to you, you are ready with those. So let us start with those. Anybody can come forward to help me in reading the LSO material. Anybody can volunteer? Anybody? Okay, let me start and then we will see that who can volunteer. You can always volunteer in between. Of course, it will be a great help to me and we will be continuing with our reading of LSO material. As I told you, visualization is the key to success in LSO exams. Let us start with this civil litigation. God bless us all and we may pass the exams. We will pass the exam. Why to call it as may? We will pass the exam since we are putting our lots of efforts and we are going to do it. And believe me, I'm not going to take your time in all these discussions here. Henceforth, we are directly concentrating upon subject matters, and of course, if I will be wasting, not wasting, if I will be investing any time in journal discussions, those will be really useful for your examination purposes. And if anybody during the regular classes or this in what you these are the regular classes, means to say the students who will get enrolled with me in regular classes, in those regular classes, means to say today we are starting whatsoever we are covering today, it will be part of our regular classes. People call it as, that is why these wordings comes from my mouth. Whatsoever we discuss today, this will not be discussed again. So believe me, of course, the recordings are there. Somebody asked me that whether recordings will be there, recordings will be there. But I always say LSO has provided us with such a vast material. It is really very hectic and difficult to do it time and again. So let us start with the LSO material, civil litigation. We are good to go with civil litigation. If you have got one of my charts, I have provided you key steps in civil litigation. I do not concentrate on charts. If charts are there to help me, why shouldn't I use them in teaching also? So let me say you all are the first thing which I would say before I start. Of course, God bless us. Second is that if you believe that you will pass, you will pass. Positivism is the key to success. And when studying, positivity should be there. You must not go to the examination hall to make a try. You must go to the examination hall to make an attempt to make you barristers. So, hey, barristers, let us start with civil litigation. Civil litigation, I have provided you one chart. If you are to cover 20 chapters, you should have index ready on your so material, because this index is really going to help you. Now let us study my chart, originating of the claim of the plan. What is visualization? Fifth time or seventh time this word has come in today's class. Everywhere it will come time and again in our classes. That is my way of doing it. Matter is in question. We need to go somewhere. Where we need to go to get redressal of our grudges, remedies, or reliefs? To the courtroom. We need to go to the courtroom. So the first chapter, jurisdiction and organization of the courts of Ontario, talks about court system. Court system of Ontario, I have provided you with another chart. These key steps in civil litigation are bound to guide us throughout our civil litigation. 20 chapters, one chart, good to go. Then, of course, as I told you, the another chart, this one, I have provided. Of course, I'm going to share it on the screen before I go with the electromaterial, because we should have a brain mapping of this chart once. Because why? Because you will be answering approximately 5 questions. That is my way of thinking. 4 questions or 5 questions in whole of your civil litigation with the help of this chart. How so? I will explain during our studies today itself. Let me share the screen if this is available. This is something. No. Let me see you that whether you are finding my screen. No. Yes, you are finding. No. Can anybody confirm whether the chart is visible on your screens?
It's not visible yet.
Okay. Okay. Let me. I will try to share again because this is going to be some basic chart. Is it visible now?
Yes.
Now let us go with this chart. With the help of this chart, we are going to understand what is the jurisdiction and organizations of the court. There is one Court of Justice Act. Once you read this chart, understand this chart, we are going to be very easy with chapter number 1, going to be good with question 4 questions in the Court of Justice Act. This is something statute which gives us an overview. Court of Appeals of Ontario. One highest court of any province is known as Court of Appeal of Ontario. Here we are talking of everything will be concentrated upon Ontario. So we will be using the word Ontario at the place of province. Court of Appeal of Ontario. It is divided into two segments. Court of Appeal of Ontario, say the highest court of a province. Another is Court of Record, Court of Ontario. Now, Court of Appeal of Ontario in itself denotes that some appellant jurisdictions are with this forum. Of course, they have got some inherent jurisdictions which are very less. Then another is Court of Ontario. Court of Ontario consists of then further divisions of the courts. But Court of Ontario in itself is not a court. Court of Ontario consists of Superior Court of Justice and Ontario Court of Justice. After Court of Appeal, if we have to go in chronological order, Superior Court of Justice, which has got inherent jurisdiction as well as appellant jurisdiction. Ontario Court of Justice is the first court for certain criminal matters we are going to study. Then further in the hierarchy, Superior Court of Justice is divided into three: Divisional Court, Family Court, Small Causes, Small Claims.
Excuse me, sir. What do you mean by Court of Ontario itself, not a court?
Court of Ontario is a court of record. So Court of Ontario consisting of Court of Ontario, there is nothing like we will be studying, of course. This is something basics I am making. You will be studying and coming to know once we will be going through LSO material. Let us continue. Superior Court of Justice has got the appellant and inherent jurisdictions. Ontario Court of Justice generally dealing with the criminal offences. Of course, the Family Law Act is also dealt by the Ontario Court of Justice. Then comes the Divisional Court, Family Court, Small Claims. Divisional Court, Family Court, Small Claims. And another is, of course, the Administrative Tribunals. Any in public law, during your this admin law in NCA, you might have read any appeal arising from the administrative tribunals will go to the court, and which court there it is to go divisional. So divisional court also has got appellant jurisdiction. To certain extent, just for the administrative tribunals. We are making a synopsis in our brain to understand the whole chapter. This whole chapter talks about Court of Justice Act, that is means to say Court of Appeal of Ontario, Court of Ontario, then Superior Court of Justice, Divisional Court, Family Court, Small Claims. Administrative tribunals, of course, when we are talking about Ontario, there are specialized courts. specialized courts, maybe commercial courts, maybe estate courts, maybe family, you will find only in Ontario. That too in GTA. Toronto region, means to say, generally speaking, please don't be, as far as jurisdictions are concerned, it is written in LSO material itself, it is written in the law that these keeps on changing with the passage of time and with the requirements which are coming across the Court of Appeal of Ontario, because that is the court which decides about the with the help of course, Superior Court of Justice, about the jurisdictions of Divisional Court, Family Court, Small Claims Court, of course, the Specialized Court and Ontario Court of Justice. Once you have this much in your mind, let us go back to our LSO material, jurisdiction and organization of the courts. Again, at the cost of repetition, I'm asking if anybody has made up his mind to volunteer.
I just need to ask one question. I was just looking at the hierarchy, and the administrative tribunals consider the matter of judicial reviews. So, is this right if I'm about to say that the case stated matter, where will that dealt with? Which court will deal with the matters of case stated?
Would you come again, please?
Can you
Word
hear
I
me?
could not. Yes, I can hear you.
Okay, I was asking, I can see from the hierarchy that the judicial review is dealt by the divisional court, leading from the administrative tribunals. So, where the
Yes.
case stated will go ahead?
Case stated, I could not get this one.
Case stated means where the excess of powers, the court has acted in excess of jurisdiction, or there is an error of law. Because normally the judicial review goes where there is unfairness, biasness, or procedure impropriety. So,
Court
where
of
will the
Appeal.
case stated?
Court of Appeal of Ontario, you can see the mark made in red color in the chart itself. If divisional court is there, then divisional court's matter will go either to the Superior Court or to the Ontario Court of Appeal of Ontario, but that depends entirely upon the statute mechanism. Whatsoever the statute is providing, only that appeal mechanism is different for different set of cases. If you are going for commercial cases, those are different. If you are going for estate, because in commercial laws also, if you are going for an immigration tribunal, the procedure is different. Even after divisional court has done any error with respect to the jurisdiction, it will go, depending upon, generally it will go to the Court of Appeal of Ontario with respect to
Oh,
jurisdiction. Now let
got
us
it.
come. Thank you.
Sir, I had one more question, sir.
Please.
Yeah, so sorry if I missed out, but the specialized courts you mentioned, so we've not shown any arrow for like on the hierarchy for that courts. So
No,
these courts are
these are the specialized courts. Like, let me say you, in specialized court, one set of courts, you will find it as family courts. And you are also finding it in the hierarchical system of Superior Court of Justice. Family courts are part of Superior Court of Justice. This is something basic structure. But in Toronto region, keeping in view the long list of cases before the courts, some specialized courts, in order to hasten the process, has been made. So those specialized courts got their power from a specialized statute, and everything not is in proper hierarchy, but generally those comes at par with the courts mentioned in this hierarchy. So let us talk about commercial courts. Commercial courts can be equalized with the divisional courts, but we cannot say it because statute is there to guide us.
okay, sir.
Okay, let us proceed further. Jurisdiction and organization of the courts. Organization of the courts, you will find one thing, that you should have a highlighter or pen or pencil with which you can mark the appropriate lines. Of course, whenever we will be reading the LSO material, we are going to pinpoint that what are the questions which are likely to be there in the exams. Of course, the concept clarity is to be there whenever we are reading, we are going through the LSO material. The Court of Justice Act establishes organization of the two courts in Ontario, the Court of Appeal of Ontario and the Ontario Court. The Court of Appeal for Ontario is a superior court of record dealing mainly but not exclusively with appellant matters. I told you that it has got inherent jurisdiction in certain matters. Of course, that is not part of our syllabus. That is why we are not going into it, which matters the Court of Appeal has got inherent jurisdiction. The Court of Ontario is a superior court of record, acting mainly but not exclusively as a court of first instance. It has two divisions, the Superior Court of Justice and the Ontario Court of Justice. This is as per the section 10 of the Ontario Court of Justice. That is what I was referring to, that Ontario Court of Justice and Court of Appeal of Ontario, Court of Ontario, we are going to read today itself and we are going to complete. And my way of doing is that we are going to read the whole of the LSO material. And if you can suggest me during our classes any other material, any other way of teaching you, I can adopt that as well. But discussion will be more fruitful if you read the whole of the LSO material in the classes. And of course, I will be leaving some part of the LSO material, but you can pinpoint me whenever I will be reading LSO material that wherever you find it, that LSO, this part has been left by me, but it is of good use in either for understanding the concept or for telling you uh, something material point which may be part of the exams. So I was reading Superior Court of Justice as a division of the courts of Ontario has three branches. Divisional Court, Family Court, Small Claims Court. The Family Court branch of the Superior Court of Justice is dealt within the family law section of the study material. So we are here not going to study the family law part of it, because once we will be discussing the family law, we will be dealing with that. Of course, the regions have been given, you can go through at their own. Of course, if you want more, you should be well conversant with what I call it as, you should be well conversant with the map of Ontario. Because Northwest Thunder Bay is the judicial center, they have told. Northeast, Sudbury, Ottawa, East, Central East, Newmarket, Toronto, these are the places where the court sits generally. According to the regions, the courts have been divided, and accordingly, if you have that map in your brain, you can have, whenever you have a case, say you have a case in Niagara Falls, then of course you can pinpoint which region it falls to. Of course, the Toronto region, Central West, Brampton, Central South, Hamilton, Southwest London. So this is something related with the map of Ontario. The boundaries of the regions are fixed by the designations of the regions made under CJA.
Can I ask you one question? Sorry for the interruption.
Yes,
So I have a doubt in this, in the hierarchy of court. Where do you file the summary judgments for interim applications for summary judgment or default judgments?
This is a part of the syllabus. If we will be running ahead, I suppose there will be many questions. Sorry, I do not know your name, but still I am at the cost of pardon, I am saying. Of course, you have a very, very valid question. But if I will be answering, we will be leading the current part aside. Suppose there is everything, the questions are valid. Where the summary judgment, where the default judgment will come from, how it will come from, in what circumstances it will come from. These are the part of the syllabus. And why I do not answer in the first instance, because it will create confusions in the class, because here we are understanding the hierarchy. We will go to the jurisdiction part, we will go to the working part, we will go, of course, to those parts of the, if you flip on few pages, I will going to pinpoint that this is something we are just reading about the jurisdiction and organizations of courts. The points which you are asking, even the LSO itself in its material says that appropriate point will be taken at appropriate time. Appellant, there is a, let us go back to the index to clear your point. There is one chapter number 90, chapter number 26, 27, 28, 29. These all deals with different sorts of things: discovery, motion, subsidiary claim, disposition without trial. 26 is the exact chapter. that if the trial is not to be there, disposition is to be made, then how it is to be. So I just request you, all of you, that please ask those questions which are relevant with the current chapter. I'm not saying these are not relevant, but we have to make a chronological order of understanding. If we will run ahead, I suppose we may not be good. Am I correct or am I okay? Gentlemen who have asked the question. Anyway, let me proceed further. I was there at the boundaries of the regions are fixed by designation of the regions made under the CJA, and they can be adjusted from time to time. Every judge has the jurisdiction throughout Ontario, although for administrative region, judges of the courts of Ontario are assigned to sit in a particular region. While explaining you the chart, I told you that whenever a judge needs to sit in which jurisdiction, that is decided from time to time. So we do not bother to our brain in which jurisdiction, which judge will be sitting. We do not have to. But next few lines are very important. I would request you to underline those or highlight those. A designated regional senior judge is responsible for administering the judiciary within his or her region. The regional senior judge works with the chief administrator of the region, the regional crown attorney, and the representatives of the regional bar to try to respond to the specific needs within the particular region. So a designated regional senior judge is responsible for administering the judiciary. So one point should be clear here, that this is something always changing. With the exception of Toronto, the population of 8 regions are roughly the same size. Although geographically the regions are quite different, legal counsel should be aware of the local differences when traveling outside of the council's area. Local branch and bar committees of the local laws association often have input to try to solve problems within the local regional judiciary, especially respecting scheduling and administrative matters. Now, the Canadian Supreme Court has come with a specific directions, or the Court of Appeal of Ontario has come with specific directions, that whenever you suppose you are practicing in a particular area, you will be enrolled with the LSO, Law Society of Ontario. You can go anywhere in Ontario and represent your clients and file your motions, applications, or anything, suits. But the point is, whenever you are doing it, you need to have the assistance of a local counsel. So at certain times in certain laws, it has been made mandatory that there should be a co-counsel, co-barrister representing you in a local jurisdiction, because the demand of the law is that you should be conversant with the local laws. Suppose I will give you one instance. If you are dealing with the Aboriginal matters, then there is I forgot the name, there is an Aboriginal association. If you take the assistance of a lawyer who is dealing with the Aboriginal matter, the whole court will be at ease. At certain times, at certain places, it is mandatory, but in other times, it may not be. So what I want to tell you, that if you go on looking for these local terminological differences, then you are good to represent your client. As far as language is concerned, kindly come to the paragraph number 2. The language is bilingual, English and French. Of course, mainly the work is carried out in English language. We are talking about Ontario. But if you want to have your case to be taken up in 2 languages, then of course you can go and file an application. The examination question in para number 2 is where in 7th line, where the document is filed or issued within 7 days of the hearing, the party is not entitled as of the right to have the hearing conducted as a bilingual proceeding. So the point is, if a party wants, they can have bilingual proceedings. That is the law in Canada. But if you do not file this application within 7 days, then lose your right. The lines to be highlighted is where the document is filed or issued within 7 days of the hearing. The party is not entitled as of the right to have the hearing conducting as a binding. Now, if party has filed the applications after that, then purely it is the discretion of you. Then coming to the you can read it at your own. Why this is the only part which I can refer as far as language is concerned, that it will be in 2 languages. Only important part is that if you do not file within 7 days, it will not be a matter of right. But if you file in 7 days, within 7 days, then it will be a matter of right. Then coming to part 1, Court of Appeal of Ontario. The Court of Appeal for Ontario has the jurisdiction that is expressly conferred upon it by the CJ and other statutes. In the exercise of its jurisdiction, the Court of Appeal also has all the powers that were historically exercised by the Court of Appeal of Ontario. This is often referred to as inherent jurisdiction, since it arises from historical precedent and does not depend on statutory enactments. Now, one question which is bothering me, you may be finding it little strange that I am reading the whole of the LSO material. Why so? Because let me submit with all humility that if I will keep on just explaining the concept, it will be difficult. Why so? Because this is not a memory test. At the cost of repetition, I'm saying that I can prepare my notes, send it to you, but that is not a practice for LSO exam. That is for descriptive sort of exam. This is our MCQs. MCQs means to say you cannot memorize all of the information available to you. You have to refer to the material. And if you have to refer to the material, my presupposition is you will have to refer each and every paragraph while studying. So the paragraph which I am leaving is of less importance for the purpose of explanation. But as far as your study is concerned, at your places, after the class, what I presuppose is you will go through LSO material once to further strengthen your brain mapping technique or your technique to understand the concepts in the right perspective. I will
just
give you, yes, please.
one question going back to the language thing, the 3 lines about within 7 days of the hearing. So is it like the first hearing, that after the first hearing within 7 days we have to file that application?
Yes,
After the first hearing, right?
not where the document is filed or issued within the 7 days of the hearing. After the first, of course, after the first, you have a specific question after the first hearing.
Okay.
For that purpose, I now let me comment upon your question, not upon you, sorry for that. Comment upon your question that there are various stages in a case. Hearing, I do not know from which jurisdiction you are coming from, but in different jurisdictions, the courts have got different scenarios. The moment we file the case, we have a hearing. In Canada, it is not the case. In Canada, hearing comes at a later stage. There are many stages before coming the case for a hearing in the court of law. So once you cross all those stages, goes to the court, hearing is held within 7 days. If you are not comfortable with the English language or with the French language, if the proceedings are carried out in French language, then of course you can go to the court and ask the court that I'm not comfortable with French language, kindly use both the languages. Then henceforth the proceedings will be conducted in all the proceedings, maybe writing, maybe oral. If the court do not had appropriate arrangements, court will make arrangements for the translators. But believe me, one thing, all the cost has to be borne by the initiator, by the plaintiff. Of course, criminal matter calls for a different, which we will be part of it. Once we will be going to the criminal law, we will be having the appropriate provisions, that what are the provisions with respect to the language. If an accused is charged with certain offense, with respect to the language. Thank you. And let us go for Court of Appeal of Ontario, which we were discussing. This has got, I already told you, Court of Appeal for Ontario is the highest court. The Chief Justice of Ontario is the president of the court and has general supervision and direction over the sittings of the Court of Appeal and the assignment of the judicial duties to whatever is happening in Ontario will be the sole responsibility of Chief Justice of Ontario. These are something very common things, but for the purpose of examination, we should know them where those are written, because once the examiner, as this gentleman has asked a question after, you will be in the same state of mind as I was, whether it is after or before. This is something examiner is looking for, before or after. And he has got a very, very intelligent question. Before or after is the most important part in LSO exams. The Chief Justice of Ontario is the president of the court, general supervision. Now coming to fourth line, which is important, you should mark it. In addition to the Chief Justice, the CJA provides for the Associate Chief Justice and other judges to constitute the Court of Appeal. The Chief Justice of Ontario, with the concurrence of the Chief Justice of Superior Court of Justice, may assign a judge to the Superior Court of Justice to perform the work of a judge of the Court of Appeal. Now, you should have one thing in clear in mind. Chart is in front of you. Court of Justice Act is there. Once the Court of Justice, can you hold down for a minute? Sorry for the interruption. Some emergency call was there. Okay, let me share the screen again at the cost of pardon. Yes, we were at Court of Appeal for Ontario. Yes, in addition to the Chief Justice, the CJA provides for Associate Chief Justice. What I was trying to tell you from the chart, Court of Justice Act provides that Court of Appeal of Ontario will be looking after all the legal affairs in Ontario. Now, you will find this ticklish things time and again, that who is acting in connivance with whom. Like you have just read, the Chief Justice of Ontario with the concurrence of Chief Justice of the Superior Court of Justice. Now, in hierarchical structure, Court of Appeal of Ontario is followed by Superior Court of Justice. Now, Chief Justice is to appoint judges with the concurrence of Superior Court of Justice. And of course, also the assignment of the work. Now, my suggestion to all of you is, you should highlight this part. Why so? Because once you are in the exam, if question comes with respect to that who acts with whose advice or in concurrence with whom, then it is difficult to remember. It is very difficult to remember us. Whenever as a lawyers, we go to the courts, we have to see that what sort of administrative part is to be referred to. Then of course, we always refer the papers. So it is always better to refer the material in the exam. If you are good with your mind, then it's very good. The Court of Appeal exercises general appellate jurisdiction of the Superior Court of Justice under Section 6 of the CJA. The Court of Appeal has original jurisdiction to determine any question referred to it by the Lieutenant Governor in Council, the Provincial Cabinet, including constitutional references. See Chapter 33, Judgment, Order, Appeals, Enforcement and Courts. of these study materials for specific appeal rights to the Court of Appeal. That is, I was submitting that even LSO has taken this point very good care of, that appropriate matter should be discussed at appropriate point when we are going through this LSO material. A proceeding in the Court of Appeal is heard and determined not fewer than by 3 judges. This is something you should remember and you should also highlight. Together and always an uneven number of judges. Then numbers can be increased to any number depending upon the matter, but it should be uneven number, odd number, we can call it as. Now, coming to 1.3, Part 2, Court of Ontario. The part, of course, one thing important I have left. In Ontario, because this is something not for exam, but general for uses, you are to pronounce with every judge justice, not Mr., Madam. You can pronounce, if at all the need arises, justice or Your Honor is the appropriate word. Your Honor or justice, this is something prescribed in the law. Judges in the Court of Appeal are addressed in the gender neutral form of justice or justice last name, as opposed to Mr., Madam, Justice. So what I'm trying to say, these are the few things which we learn which are really useful for the purpose of our practice as well. This is something which we learn from our material and use during the course of our profession. Now, Court of Ontario consists of 2 divisions, Superior Court of Justice and the Ontario Court of Justice. The Chief Justice of the Superior Court of Justice is the President of the Court of Ontario. Superior Court of Justice, Divisional Court, Family Court and Small Causes Court. Chart is in front of you, the same thing is there. Now we will be coming to the real jurisdictional part of the Superior Court of Justice, Divisional Court, Family Court, Small Claims Court. Then, of course, this whole of the chapter talks about these ticklish things in a regular manner. Regular manner means to say that this will describe the technical details and you do not have to mark them up, you have to mark them and you have to understand. Superior Court of Justice is a superior court of both civil and criminal jurisdiction. And very serious nature of offense is there, Superior Court of Justice. When less superior nature of case is there, Ontario Court of Justice. I repeat, Superior Court of Justice, very serious criminal matter is there, because the confusion comes once the criminal matter comes in. Ontario Court of Justice do not undertake the matter pertaining to the civil nature. But Superior Court of Justice takes the matter pertaining to the both civil as well as criminal. Now you can jot down with your pen appeals which are greater than $50,000. 50, if the appeals are of the value more than $50,000, then those are to be taken. What I need to say, I forgot. Why I forgot? I'm telling you truth, I forgot. Why so? Because whenever you are reading your own written material, you may be able to say something which you forget. This is something natural process. And you should not try to override the natural process. Then you should read the few lines. If you do not find your answer with respect to a particular question, read few further lines, then you will get answer. If you still do not read, class is there, we will try to answer. But kindly keep it in pending because you will get an answer. The Superior Court of Justice consists of a Chief Justice who is also is President and Associate Chief Justice and is Regional Senior Judge. For each region, the Senior Judge of the Family Court, such number of judges as is fixed by regulation. These all are important, but let us move down to the last paragraph. You can read it at your own. Again, Your Honor, you can call it, or Justice, you can call it. Gender neutral it is. In addition to its second last paragraph, in addition to its original or trial jurisdiction, I'm making an interruption and telling you that we are reading before we go for a break, because there is a scheduled break after about 1 hour 20 to 25 minutes. This will be a general trend. Then we will be coming after 15 minutes and rejoining the class. And after rejoinings, there will be like, we will be continuing where we were. That will be the normal course in my classes. And if you have anything else to suggest, I will be ready to adopt if everyone agrees to that. So one thing is clear over here. Once we we will complete the Superior Court of Justice, then we will go for a break. We have to be gender neutral in all the courts in Ontario. But if anybody wants to pronounce themselves with a gender, then he or she or anybody needs to write what pronouns I can use for him or her. This is a PR question as well. Because people do mind if I pronounce wrongly. Suppose voice suggests me he's a gentleman. I pronounce him as a lady, gentle lady. Then she may mind, because I was of the opinion that he's a male person. Later on, I find it as female. So we are going in the courts with gender neutrality in our mind. With respect to the judges and with respect to the clients, when we will study PR, we will have a descriptive thing about the pronunciation. Regarding the, what do you call it, not pronunciation, about the addressing of anybody in the court of law and with respect to your clients as well. Now, associate judges, in second last paragraph, in addition to its original and trial jurisdiction in civil matters, the Superior Court of Justice has some jurisdiction in appeals, including an appeal from an interlocutory orders of an associate judge and an appeal from the assessment of costs in the proceedings in the Superior Court of Justice on an issue in respect of which an objection has been served pursuant to Rule 17B. So there are certain interlocutory orders, the appeal of which lies to the Superior Court of Justice. What are those? We will study in an appeal part. You can jot down, which I have told you, appeal greater than $50,000 will go to Court of Appeal of Ontario, if I'm not wrong. I told you, I forgot. Now comes the associate judges. This is a new term coming for the first. There may be some persons who may be conversant with the old material or old term. What should I call it as? Even in my charts, I have used that term because I'm going to revise that chart. This was not a mistake. This was categorically done. Case management masters. What I call it as civil, I have used it in what I call it as case management masters in superior courts. Now there are no more case management masters, because usually in the exam 1 or 2 questions pertain to the case management master. Now they are called the associate judges. You can write it earlier known as case management masters. Are appointed provincially and sit permanently only in Toronto and Ottawa. Toronto and Ottawa, due to its populations, has got the permanent seat of sitting. Associate judges have all the jurisdiction conferred upon them under rule so and so. 86(1.1) sub rule 6. In certain center, associate judges travel here on scheduled days. Motion within the jurisdiction of an associate judge can generally only be scheduled on a day when an associate judge is scheduled to be in the region. So days have been fixed when they are traveling outside Toronto and Ottawa, and during those days only motions can be filed. Now, for the purpose of understanding, which I was referring earlier as well, that assistance of the local lawyer is required, because these day. Suppose you need to make a motion in the court, you do not know which day. Suppose the day was Wednesday and you reached at Thursday, reached on Thursday, then you have to wait for another 6 days to file that motion. To have hearing of on that, if it is of urgent nature, you will be in difficulty. So it is always advisable to take assistance of a local lawyer if you are traveling outside of your jurisdiction of your usual place of practice. Judges schedule. Associate judges have jurisdiction to hear most motions except a motions. Now kindly write down exceptions for hearing for associate judges. These are the exceptions. Associate judges can hear all except these. Reserved to be a judge by a statute or a rule. Statute does not allow, do not hear it. To set aside, vary or amend the order of a judge. If judge has made an order, associate judge cannot interfere. To abridge or extend time prescribed by an order that an associate judge could not have made. If the judge do not have the power, the associate also do not have the power for judgment or consent in favor or against of a party under disability. They cannot make any order relating to the liberty of a subject under section 4 or 5 of the Judicial Review Procedure Act, JPRA Act, in an appeal. So these are the exceptions. You do not have to remember. The basic question which is asked by us when we were students, sir or ma'am, we were not gender neutral. Do we need to mug up all those? No. Then how? We should have a tab, or we could recall that where it is. Then we should go to that page, refer to that page, and then try to answer the same. While judges have jurisdiction to hear any motions in a proceedings, in center where associate judges are present, a motion that within the jurisdiction of associate judge shall be heard by an associate. You cannot take what is authorized to be heard by an associate judge to a judge, because it will burdensome. It will take matter, whatever comes within the power of associate judge should be heard by associate judge only. In these centers, a motion made to the court within the jurisdiction of association judge will be heard by an associate judge only. Now, third component, first are the judges, second are the associate judges, third are the assessment officers. Assessment officers are appointed pursuant to section 90, subsection 1 of the CJ, and have jurisdiction to assess cost of any court proceedings. Let me say you, once you will be going through whole of the civil litigation, you will be finding that role of the assessment officer is super duper important, because cost is the main criteria which decides the fate of the litigation. You have to bring the suit down. Suppose you are claiming $2 lakh, $2,10,000, but you need to bring it to the jurisdiction of the court, concerned court. I am not naming the court. Then the plaintiff has an option to decrease that from $2,10,000 under $2 lakh. So once this option, jurisdiction is made out. In other common law jurisdiction, generally speaking, from my past practice, in my home jurisdiction, this was not the provision. So this provision is really, really very helpful to cut the cost factor. And who tells you about the cost factors? The assessment officer. Of course, you will be ready to assess the cost as your own. But if the administrative order with respect to the cost is to be made, that is made by the assessment officer. So traveling down the line from the chart, which is there on your screen, we have reached to a scenario of internal mechanism of superior court of justice. That is what is the reading of step-by-step process. Once you are
Right.
conversant with, yes, please.
So just one question, there's a down arrow from superior court to divisional court covering final order less than 50,000, interlocutory order and master final order. So these matters go from superior to divisional court. Like,
Brother, I'm not referring to all the matters put it in this chart. That is why I I feel an apology that I needed to write all these things in this chart, whosoever have made this chart. But the point in question, if I will take up this matter that what is the jurisdictional part, then we will be overreaching our LSO material. This will come step by step. We will go step by step. Let us read in a structured manner. The point is, if I will start taking the jurisdictional part, that which appeal is to go to which court and what will be the amount in question, we will be overreaching the material. Time and again, I will keep on telling you, let us understand the structure, because structure in itself is very complicated. And if we will, that is why I stopped. I told you I forgot. I told you to write appeal greater than $50,000. Then immediately I forgot. Why I forgot? Actually, I forgot. Why? Because if I will not forget, I will be overreaching LSO material. And it will not be helping us to understand the proper concept at proper time. This is of utmost importance in understanding. If you go on reading this chart and try to understand all the concepts written in the chart, we are going to use this chart, believe me, throughout our civil litigation reading. And this chart is of utmost importance, I'm again saying, to answer approximately 10 questions in your exam. How you will be, by the end of the time, when you will be completing your civil litigation, you may agree with me. I don't force anybody, but you may agree with me. Once you complete it, we will. So coming to the concluding part of the Superior Court of Justice, before we go to break, last component, judge, associate judge, assessment officers, registrar and other administrative officials are appointed, means to say staff is there, registrar. Registrar happens to be one of the very, very important part of the court system in Superior Court of Justice and in the whole of the court system itself. Registrar and other administrative officials are appointed under Part 3 of the Public Service of Ontario Act. Registrars now exercise considerable authority to make certain specific order on consents. Now the first point has come about registrars. If consent decree is to be made, consent order is to be made, then they do not want to bother either the associate judges or the judges. The registrar has been empowered to lessen the burden on the judicial decision-making process. The registrar and other administrative officials are appointed, order on consent except where one of the parties is under a disability. But if one of the parties to the case is under a disability, then they are not entitled. Then comes very important duties of registrar. Consequently, before the registrar can act, the consent must state that no party is under a disability. Consent order may be made by the registrar. Very important to note, kindly, you can number them or you can underline them. You can, on my material, I will show you my material, how I go for it. I write it like this. Because whenever you will be shifting yourself to LSO material, it should be easily visible. Duties of registrar. And once you have written on the left-hand side duties of registrar in this horizontal form, it will be always easy to recall. These duties: amendment of a pleading, notice of an application, notice of motion. Kindly note down when we are reading this, how important these are. Amendment of a pleading, very important. Lots of court code time is saved. Notice of an application, notice of motion, addition, deletion, or substitution of a part. Removal of a lawyer as if a lawyer of record. One party wants to change the lawyer, registrar has got the power. Setting aside a default judgment, party is not turning up, default judgment is to be made. Who writes the judgments in Canada? The lawyer. Lawyer writes the judgment. So setting aside a default judgment, discharge of a certificate of pending litigation, security for cost in a specified amount, re-attendance of a witness to answer the questions on examination, fulfillment of undertaking given on an examination, dismissal of a proceedings with or without cause. So these are the subject areas of duties of registrar. In such a large number of matters pertaining to a suit or a case, the orders are made by the registrar. A motion made to the court within the jurisdiction of a registrar will be dealt with by a registrar only. Now, up to here, of course, today is our first day. I'm taking a lot of time. That is why in the span of 40 minutes, we could able to read only 3 pages, less than 2.5 pages. And we could pinpoint many things which will not be repeated in the days to come, for the simple reason because you will be conversant with me and you will be easy to grasp the things in the proper perspective. Now, let me say you last thing before we go to break. Please come back and do have this pen and paper ready with you, because here onwards, we will be pinpointing many things. We will be going a little faster. And one thing is very clear, certain things we just need to tag only, because go through once, tag, then whenever the need arises, come back and see what we need to pick it up. Says this is the lengthy list of duties of registrar. Duties of registrars will only be recalled once you need to make a decision that what decision is to be made by a registrar, on which most of the matters have been covered. Maximum matters have been covered. I mean to say the stages in a case. So let us go on a break. Let us meet after 15 minutes. Precisely 8:36 is there. 8:50 we will be back. 14 minutes. Thank you, and please do come back. I will be stopping the recording and then we will be having the another recording once we will be coming back.